129, 45 CO1, 1207 MI 118. I'm going to go with the 9:30 call to begin with. I believe that most of these are status conferences emanating out of objections to petitions for tax deeds. Is that correct? Attorney Wiley?
I believe so, Your Honor.
Attorney Wiley is here on behalf of the Lake County Auditor's Office with his representative, Ms. Scheidt. Do you have any time this morning to ascertain which status conferences might be fairly quick?
I have it, Judge. There's a sign sheet by the attorney.
All right, Christina Bruno. Good morning.
We're on two different matters. The first is on certificate 451304528.
What's the name?
Nebraska Alliance Realty Company, former owner is Donald Warren, and I represent JP Morgan Chase.
Okay. That's probably the second to last on page 1 on the call.
Looks like it.
Do you have a key number?
Yes. 450833 483-002-000-004.
Okay, yeah, that's the second to last item on the call on page 1. So, Attorney Bruno, you represent JP Morgan Chase Bank. And Attorney,
Mershot.
who do you have?
I represent FLRC Land Trust.
FLRC Land Trust. Is anybody here for Nebraska Alliance? No. All right, and is this a request for a surplus?
It is, Your Honor. FLRC Land Trust purchased the property after the tax sale, but before the deed from the former owner, who was Chase's borrower. We filed conflicting petitions for tax sale surplus, and then we filed a motion for summary judgment on our petition last week.
Okay. And how much time are you going to be able to get a response on within the 30 days contemplated by Trial Rule 56, or do you need an extension?
I will, Judge. That's fine.
Okay. Till?
30 days.
I'm sorry. Oh, you will be able to? What about your reply? Do you contemplate filing anything, Attorney Wiley?
No.
Excuse me.
If we can have 14 days after his response.
Well, you'd have 15, so. And so we need a hearing date. When did you file your? When are you going to get your response on file?
I just received it yesterday. They filed it late last week, so I just received it yesterday. I should have a response on file by...
Why don't we do this? Can you have your response by June 30th?
Yeah, that's what I was going to say.
All right, we'll put the minutes on response to summary judgment due June 30, 2015. Okay? Your reply brief is due July 17th. Is that sufficient time? Reply July 17, 2015. And we'll give you a hearing date on the summary judgment. August 11th. At 11. August 11, 2015 at 11 a.m. Yes? Anything else? All right, and Attorney Bruno, you said you had another matter?
I do. Parcel number 450224479020000023.
All right, Al Cervic, JP Morgan Chase Bank. It's the 1, 2, 3, 4, 5, 6, sixth item on page 2. You represent JP Morgan Chase Bank?
Yes, sir.
Okay, is Attorney Pipazar here? I think he had represented, or Attorney Polk. Didn't they represent?
They represent the buyer, Judge.
Failed to appear. Is this also another surplus?
It It is terminated.
Okay, we're set for status.
No, actually, no objection to the issues of surplus or J.D. Chase. You might recall last cattle call, this was on the dock.
Oh, is this the one that was on, and then we said it was, yeah.
We were told that the surplus had been paid when it had not been. And as a result, we placed it on today's call for.
All right, so the petition for surplus is granted.
I have a proposed order.
Do you? Okay, very good. If you can just put it on the table.
Thank you very much.
Attorney Bruno, anything else?
No, sir.
Okay, you're welcome. Attorney Deutmeyer? Okay, I couldn't read exactly. Deutmeyer. All right.
We're here on
And that's D-E-A-T-M-D-E-D, okay. That's,
handwriting's now like a 2-year-old.
yeah, well, mine's not much better. All right, okay, which one is it?
Key number is 4550.
Well, give me a name first.
It's Tom Cedar Lake. This is the auditor, the treasurer, Louis W. Bilmer, and his heirs.
Okay, I see it. Page 2, the second item under the MI 118. And you represent whom?
Tom Cedar Lake.
Okay. Anybody else here on that case? Anybody else fails to appear? What's this one set for?
We're here on the town verified petition for the issuance of tax deed.
Was there an objection filed previously?
No, sir.
Any objection to deed? Have you had an opportunity to review the...
Yeah, no objection to that.
All right, petition granted. Have you filed your proposed orders?
I believe it is previously filed. I have one with me as well if you need one.
If they've been previous filed, then no.
Okay.
All right, very good. Any other matters?
That's all.
All right.
Thank you.
Yep, Attorney Golden. Good morning. Michael Lofton.
Tried to determine if Bruce Leaf was present. I recall last time before he was here, he was very adamant that he was going to be here today. And
Bruce Leak? It's Bruce Leak here. Is that who it was, or was it another?
no, I recall Mr. Leaf.
Okay.
He was here, and I asked him to remind him that he needed to be here on the status date, or that he might be issued in his absence, and he was very adamant, I'll be here.
All right. Let me just check that file real quick.
And I'll represent to the court that on or before May 22nd, I sent him the proposed exhibits that the court agreed to send.
All right. Court will grant the petition. And have you filed your proposed order?
It should be in the file, Your Honor.
All right. Next.
One is Raleigh is here.
United Nations Alliance versus House of God. Attorney Golding represents United Nations Alliance. You are?
Richard Rowley here on behalf of the House of God.
Okay. Have you exchanged discovery?
Yes, we have.
Have you had an opportunity to discuss potential settlement?
At this time, I have not, don't have any authority from my client to settle the matter, so I would ask that we just set a trial date in the hopes that that motivates the settlement.
Okay.
That sounds good.
How much time for trial? Hour, half hour? Say it again?
No more than half an hour.
Okay. How soon?
Well, he's propounded a little discovery to me, so I'll be able to set the trial out in like 60 days.
Okay. How about August 11th, 2015 at 11?
Should be fine.
That works.
All right, anything else?
Do we have prior hearings that day?
I just set one.
Like it prior to 11:05? That's a Tuesday.
It is a Tuesday. No, we don't. I have some summary judgment hearings at 9:30. That's why I picked 11.
Okay.
Figured you could sleep in.
Thank you.
You're welcome. Anything else? Attorney Tweedle? Oh, wait a minute, you got one more, don't you, Attorney Golden?
There's this matter, Ramon Wilkes versus LDARE with Shannon Lewis. A bit of background, she had filed a petition for extension of redemption period. My client is the owner of the property and had objected to that. The petition for extension of redemption period was denied, and I think they want a refund on the property now, so of the money they paid in tax sales. So I don't really have a dog in that fight, really, Your Honor. So
Your Honor, when I talked to Attorney Brandon, that's it.
It is.
When I talked to Attorney Brandon, basically all he needs is proof of the notices. I'm file full of stuff, but I don't see that I have the actual notice. So,
As a statute provides, Your Honor, if they did no notification of 4.5 or 4.6, they're not entitled to a refund. They made a bona fide effort, they're entitled to a refund minus 25%. So
Right.
before she approved me, they didn't make a bona fide effort. I would encourage you to refund minus 25%.
and we'll just, we can, if I can find it in the office, then we will ship it to them next week.
All right, we'll continue this to August 11th, 2015 at 11, and hopefully you can sort it out by then. Attorney Tweedle? Good morning. First one, Shikar Guha.
Do you have security password tax number?
Tax number, middle numbers are 28201.
Okay, 3720 right there. Is that?
Shikar Guha.
There was an objection on this property. Just a little background. I expected the division to be here since they put together pretty extensive pro-state materials to object to. So this process, we didn't file a petition. The reason is, in the very beginning, we had quite a number of properties, and we were ordering title. Before we were ordering title, we were filing 137Gs, and we kept really busy in the auditor's office processing those. And one of those came back. Any ones that were redeemed, they let us know so that we didn't go ahead and order title order.
Okay, so this one, I believe the file got opened up based upon the petition to set aside the tax deed. But you haven't even filed a petition for deed.
We're willing to, we're not going to file a petition. All we're asking for is a refund in this case because the only reason why we didn't proceed is because in the very beginning, one of those 137Bs was returned us with just an R markup that it had already redeemed. You know, and I talked to Gina about it in the past. I mean, and they process hundreds of them for us. This is just one search.
Attorney Wiley, what's your position?
This Shike is to confirm that that's what happened in case Judge that never knows what Judge got her file. If that's the case, we have no objection.
I think the confusion was this, that it had redeemed from a prior sale, and so in the computer, it looked as if it had redeemed.
So we just did that status date check. We'll work on prior to that.
Okay, that's fine.
Yeah, I'm sure you will. I mean, because, yeah, if that's the facts, then I would order a refund. Excuse me. We'll continue that to 8, 11, 15, and if you reach an agreement, you'll need to file that, and I do want something in that agreement reflecting that there was the objection and noting that any petition for deed that will or may have been filed would be denied, just so it's clear that, that this is also ruled on. You understand?
What did you say that the court acknowledges no petition for deed has been filed?
Whatever, yeah, no petition for deed has been filed, and therefore their motion to set aside is moot. It's something that makes it clear on the record that there's... Right.
Certainly.
All right, it's for the minutes, though, we'll continue until August 11th at 11. And then you have U.S. Bank Custodial versus Lopez.
This is just a...
Second page. Benjamin Lopez.
Yes, petition for deed has reviewed my notices.
Was there an objection made?
There's no objection.
Okay.
No objection.
Petition granted. Have you filed your orders?
The orders are in the file.
All right, very good.
Thank you.
Anything else at 9:30? All right, Attorney Hall. Good morning.
First one's on page 1, third one down,
Premier Holmes.
Premier Homes. On this one, Judge, we just need a hearing date. File date.
Do you want me to do them on the phone?
No, that's not it.
Oh, that's not it.
No.
Okay.
I'm sorry, who do you represent?
I represent MCG Housing.
Okay. And Attorney Bratz, is he still, oh, here he is.
Premier Homes.
All right. And this is a petition for deed and an objection there too?
Right.
Okay, have you been able to conduct the discovery necessary to get it to trial?
I will need a little bit from the auditor, nothing from, Ross has given me everything from him. This is going to turn on a legal issue, I don't believe a factual one, but
Okay, how much time do you need?
I would think an hour.
Attorney Bratz?
That's fine. We should do it.
What are we looking? Where should I be looking?
Obviously.
Okay. August 11th at 11?
Coming with me, so
I think we can, that'll,
11th at 11?
yeah. I think we can get, I think that's the last one we'll put there.
Want me to send it?
But that motion for summary judgment shouldn't take long, should it, on the refund? Yeah.
That's fine.
Right, and then, Attorney Golding and his, and then this one, we should be able to get those three done in an hour. Attorney Hall, if it's just a legal issue, you don't think you'll need the full hour, will you? Okay. All right. Any other issues that we need to address with regard to that? All right. Attorney Hall, do you have any others at 9:30?
Page 2, Judge, like real estate.
Golden Path Realty?
Yeah. This one, Judge, we we actually had a hearing here on this one across the hall a month or two ago. This one also turns on legal issues. Since that hearing, though, I've discovered some case law that...
Okay, let me get this set first, though. Attorney Hall, who do you represent?
I represent Yolanda Kelly.
Oh, wait a minute, no, this is, that's not the one I thought we were looking at, but...
I'm sorry.
Golden Path versus LakeCo.
Oh, okay.
Aren't you on that one?
Yes, I'm on that.
Okay, that's the one I was...
I'm sorry.
That's right.
And this one, we just need to set a hearing date. And I think this is on Justin Murphy.
Yes, I got we got basically a fax for a continuance saying that he was admitted to the hospital and had surgery last night and was released, but can't be here and would like to appear telephonically.
And that's fine.
Can you,
I've spoken to Justin on this one before he entered his appearance.
well, are we going to need to schedule any, I mean, he filed a motion to intervene, correct?
And we have no objection.
Okay. But the next step then is to probably set a hearing?
Correct.
So we will need to have him on the phone to schedule that. So let's go ahead and see if we can get him. Attorney Hall, you represent whom?
LH Property.
LH Property. And Attorney Rodriguez, who do you have?
Golden Path, yes.
Okay. And who does Attorney Murphy have?
Mr. Gonzalez.
Yes, Guadalupe Gonzalez.
Oh, are you here, sir?
Just hold on 1 second.
Come on up. Yes.
Are you there, Mr. Attorney Murphy?
I am.
All right. We're on the record in Golden Path Realty versus LH Capital Management. 45 CO1 1308 MI 129 concerning key number 45-02-36-482-020.000.023. Attorney Murphy, can you hear me?
Yes, sir.
Okay. Attorney Murphy is here on behalf of Guadalupe Gonzalez,
Correct.
correct?
Correct.
Attorney Murphy?
Yes, Your Honor.
Yes. And your client is here in person also. Attorney Hall is here on behalf of LH Capital Management, and Attorney Rodriguez is here for Golden Path Realty. We all trust you're okay?
I had emergency surgery yesterday. I'm all doped up on drugs, and I hurt like shit, but I'm okay.
Fair enough. All right. With that, there's a motion to intervene that you filed. Attorney Hall, Attorney Rodriguez, do you have any objection to the motion to intervene?
No.
Attorney Wiley?
No objection.
All right. The motion to intervene is granted. With that, where do we go from here? Is there discovery needed?
Apparently, from the intervener's position, there would be. I'm not so sure, but I think the intervener has best claim to title, and I would probably want to do 1 or 2 depositions. I'd want to do a deposition of Mr. Hall's client as well as the other purchaser. As I understand it, the property was sold first to my client. I understand that LH Capital had applied for the deed, but had actually not obtained the deed. My client paid for the property, paid for the current property taxes to receive the deed, didn't receive it, and you have otherwise the rest of the court case in front of you. My client's put $87,000 into the property, so he has an equitable interest, obviously, more so than anybody else, as far as I know.
Okay, well, let me stop you there. I'm getting, from the attorneys in the courtroom, your recitation of the history behind it. I'm getting shakes of the head no. So, obviously, there's going to need to be some discovery done, and you'll all have to try and get on the same page as to what is going on. So since we're the status, what are we thinking, 90 days for discovery?
as long as everyone will cooperate with depositions, I can send out death notices next week. 90 days is fine with me as long as everyone that's going to respond.
Okay.
My client's from California, so
We can stick to 60 days.
It was 90 days sufficient then?
I would hope so.
Okay. Well, we'll set a discovery cutoff of, what are you doing first, basically? Do you think you can get your discovery done by August 31st? Anybody?
I do.
Okay. Okay. If that turns out to be problematic, just file a motion to extend the discovery cutoff.
Do you want to set a final hearing too? I don't see this is going to go away on a summary judgment.
Yeah, no, my next step was going to set it for trial. I just want to get a discovery cutoff and then go from there. So August 31, 2015. How much time for a trial? Are we looking at a half day or a full day?
I would think a half-day, Judge. This was going to turn on...
I would think a lot of it could go by stipulation. We could probably do half day.
Okay. I'm hearing Attorney Hall saying half day, Attorney Murphy half day, Attorney Rodriguez. Okay, all right. Let me look for a half day then. August 13th at 1:30. I'm sorry, that's before the cutoff, isn't it? So, yeah. Just have my book open to that page. September 22nd.
Works for me.
Fine. What time?
9:30.
Judge, if that date works for everybody else, would you possibly order a mandatory settlement conference with the parties and counsel? I think that the issues here are ones that maybe we could resolve before we appear before the court.
Yes. Parties will conduct a mandatory settlement conference by August 31st, 2015.
Thank you.
And then the bench trial hearing will be 9/22/15 at 9:30. And the motion to intervene is granted. Anything else we need to address?
I sincerely appreciate you letting me appear by phone now.
No problem. We'll hope you feel better.
Thank you.
Okay, very good. All right, Attorney Hall, then back to you. Mr. Gonzalez, did you hear all those dates?
I heard all those dates, and this should have been done yesteryear. So far, it's all planned on the third year. I'm losing money as it is right now.
Well, those are the dates, and my suggestion to you would be to give your attorney a call so you can figure out what goes on next.
Right.
Okay?
Will do.
Attorney Hall, you have
Kimberly Mays versus Kevin Hines.
Kimberly Mays, Kevin Hines, anybody here on that? What's this set for?
Petition for a deed. I don't know what happened. At our last cattle call, I represent Kimberly Mays. She had several properties. I thought it was on the call last time we were here. I went through the notices with Mr. Wiley, and we had no objections were filed. Turned in the orders, and we didn't get them back, and we called to find out why. And we were told it was not actually on the call that day.
Wasn't set.
So
Okay.
I resubmitted everything, and it's been set to today. No objections have been filed.
Attorney Wiley?
No objection.
Petition is granted.
I have new orders with today's date on it.
All right, very good. All on the table.
I'm assuming we screwed this up, but I don't know.
Well, I'm sure it wasn't me. I'm positive it wasn't me.
I agree with that. That's my sword here, all right?
I agree with that assumption,
All right. Willie Hall and Yolanda Kelly? Is it?
Yeah, this is the one that we actually had a hearing across the hall some time ago. However, since then, there were some cases cited that day that there have been subsequent cases that have greatly limited the holdings that were being relied on. So here's what I would suggest is that you let us submit a brief on it, because it turns on purely illegal issues.
Yeah, what was the issue again? Remind me.
The tax sale purchaser had requested an extension of redemption period, which was granted. Tax sale purchaser never sent out a 4.5 notice. We filed an objection saying that their interest in the property had lapsed by failure to do so. They said, well, they relied on a case, I forgot the name of it, where the court had equitable authority when a tax sale purchaser was given erroneous information by the auditor to extend the redemption period by ordering the auditor to reissue the certificate, thereby triggering a new period of time. However, there's a case that came out a year or so after that greatly limits the holding in that case to only a circumstance where the auditor's office issues erroneous information that the tax sale purchaser relies on. And in that, the subsequent case, and it came out of this courtroom, not before you were here, says that under any other circumstances, the court does not have the authority to extend the redemption period. So I would just say, let's submit a brief on it. You had taken it under advisement.
Right. Okay. So, who do you have? Yolanda Kelly. Okay. All right. So then, how much time are you suggesting?
Well, I could have mine done in 30 days, but I forgot.
Kenya Jones.
Lewis was.
Kenya Jones.
Kenya Jones was on the other side.
All right. Well, why don't we do this then? Is we'll parties to submit further briefing by June 30th. And I'll ask that you waive the trial of 53.1. But I thought we did. Okay, so that's been waived? Okay. All right. All right, and then I look forward to the briefs. I always look forward to see some, the laws is all over the place. So. Yeah. Attorney Rodriguez had her name, but I think she was on the other case, so she's gone. Attorney Mershaw. Page 1, FLRC Land Trust, number 6523. What's that set for?
Judge, I've got 3 cases. That one is set today. No one appeared last time, and it's for the issuance of surplus.
Attorney Wiley, any objection? Yeah, let me find those real quick. I may have said it because I was unsure whether you noticed everyone that may or may not have a claim. Who is FLRC Land Trust as to the surplus?
FLRC purchased the property, I believe after the tax sale, but before that's been in ownership via equipment.
Okay, was the record owner at the time of the tax sale notified of the petition for surplus?
I believe so, Judge, but I don't have the petition here in front of me.
All right, let me find it.
I have my version of the cloud server, but not the actual file version.
Also, Judge, in those situations, normally the owner at that time when they file the claim deed, file a disclosure of surplus. They're aware of the surplus.
I know that was filed and stamped. It was filed as exhibits to my petition. So the copy of the tax deed, the tax surplus disclosure form, and the written claim deed were attached as exhibits to my petition.
Attorney Wiley, any objection?
No objection, Judge.
All right, have you, let's see, I've got it in front of me. I don't see a form order in here. It could be down at the bottom.
I created some orders, Judge, but I'm not sure protocol in this court exactly as to how those orders should be worded, but I'm happy to submit the orders that you have.
One moment, Judge. Judge, Gina has reminded me, now that I look at these, all three quitclaim deeds that were filed by FLRC were rejected by the auditor's office. I don't recall the reason. Correct all three. So as a result, right now, the auditor's records, FLRC is not the record holder entitled to surplus. As a result, I have to object for legal purposes so they can rectify that issue. My assumption is they may have to just do a further their affidavit, something to confirm that
All right, let me make sure I'm clear. Are you saying that the legal description on the tax deed was inaccurate or on the quitclaim?
quitclaim.
Cool.
Judge, just for clarification, the bottom one on page 1 of today's call, no objection, that deed did go through, so we have no objection to surplus on that. It's the next two.
On the 23?
Yes.
Okay, so on 23, petition granted? Yes?
Yes, Your Honor.
All right, and then order tendered. Have you had a look? Do you want to take a look at the order? Attorney Wiley, do you have any objection to the order as prepared?
No objection, Judge. You just need to add the parcel number.
I'll be tendering here in just a minute, Judge. They won't-
All right. Excuse me. All right, so then the next two, on the top two items on page 2 of the call, Attorney Mershaw's here for FLRC Land Trust on both. All others fail to appear. Attorney Kavachkov, you're here on one of those? Which one? What's the key number? Have you entered?
I have. We actually also filed a petition for surplus.
Dueling?
The number is 45 12 20 103 003 000
All right. Okay. All right. So, Winnering LLC got the tax deed. Attorney Bratz, are you on behalf of them or no?
Yes.
Okay.
I really didn't have a stake in the horse in the race, so, but I'm familiar with that case. The surplus.
Well, you had filed a motion for an order directing the Lake County Auditor to apply the tax sale surplus to taxes payable in 14-15. Are you still pursuing that or not?
We would ask that be taken out first, because taxpayers liable until the date that they no longer own the property, the taxes. So we would ask that that be taken out, and then the surplus divided as the court sees fit.
Okay, Attorney Kavachkov, let's, all right, so, just so we get this clear, we've got FLRC Land Trust appearing by Attorney Mershaw, Winnering LLC appearing by Attorney Bratz, and Attorney Kavachkov, who do you have? Barden Procurement Group, Attorney Michael Kavachkov. Okay. All right, gentlemen, you tell me what you want to do.
Pretty much I want to discuss it beforehand. My client is part of the procurement group. He's a third party seeking surplus in that 7.5 provision. So his interest is limited to 10%, which Mr. Marshall's client is agreed to pay out. I just need to discuss with my client the contract that he signed with the owner of record at the time the property was sold. We discussed setting up a final date and hopefully we can come to a resolution before then.
Attorney Bratz?
If they would have no objection to taking that money out of reimbursing the LLC, the taxes that they have to pay until the rest of the property. I don't know if you're going to agree with that or not.
I don't have authority to agree to that at the moment. I don't know what that amount is either, but we can discuss.
It's probably about $15,000. It's not much.
My client's a reasonable man, and I think we could probably do that. I would say discuss it today, but
All right, how about we reset this to August 11th at 11 a.m.? Yes?
Yes,
good judge.
Parties will conduct a mandatory settlement conference and conclude that by July 31st, 2015. I'm going to set it for status on August 11th. Anything else?
Judge, I'm going to go ahead and tender the orders on the other case with the scrivener's error on the quitclaim deed, and we'll go ahead and file for, to correct that quitclaim deed.
Well, which one are you talking about? You talking about the next one that we're about to call?
Oh, I'm sorry.
Okay. FLRC Land Trust 6870, that's parcel number 45-12-09-352-080.000-030. All of the parties failed to appear. All right, and then this is the one, Attorney Wiley, that you said you have an objection to because of the issue, deed issue?
The claim deed is filed by the client. Improper, Judge, and it just needs to be rectified. I assume, I think it's a legal description issue, which you can probably rectify through scrivener's error affidavit. I'm not sure you have to go back to that owner to do the deed. To accomplish that, but if he wants to contact me here, so you can understand the state, it may possibly violate agreed motion.
All right, I'm going to reset it to August 11th at 2015 at 11, and figure that we'll get all that paperwork squared away and
Nothing further, Judge.
all right, Attorney Driscoll?
Morning, Judge.
Good morning.
I'm here for Adela Johnson. We're here in status. Attorney Kravachkov has brought an objection on behalf of his client, and we just need to process it.
Page 1, Judge, it's like third from the bottom.
Oh, Adela Johnson? Okay, Attorney Driscoll, you have Johnson?
Yes.
And Attorney Michael Kravachkov is here on behalf of Wayne Collins.
His sister was deceased, I guess her estate, Bernie's Collins.
The state of Bernice Collins?
And her husband is Arthur Gill.
All right. And have you been able to exchange all necessary discovery?
The only thing I need to know, Attorney Driscoll, is the notices.
How long for a bench trial?
Yeah, I mean, approximately half an hour, no more than an hour.
Okay. What do you want me to look on the calendar for that?
We discussed approximately a month,
Well, that would, but I have not been noticed with what discovery was due 10 days ago, and I haven't been propounded with anything. So I'm ready to keep the trial from discovery.
I guess the error would have been on my English counsel research was ordered to provide discovery to my body. I think it was 22nd June. And I definitely should have replied. I forgot the order.
I mean, I'm going from the order from last one, the discovery was due May 22. So I'd object to discovery application. I'm prepared to proceed to trial.
I'm sorry, did you say that you provided everything to them?
I haven't been propounded with the request.
He wasn't at the previous hearing, Your Honor.
Okay, well, the previous hearing, what I order at those hearings is that you provide all the documentation that you're going to use at trial.
Okay.
So if you haven't done that, you haven't done what you were ordered to do.
Okay, well, in that case, I'm going from the order I got, which just said discovery was due.
Now, what I expect when there's an objection made is that everybody exchanges what they intend to use at trial. So when they come back here a month later for the status, I can figure out if there's any additional discovery that needs to be, done, how much time for a trial, whether the case is one that might be settled, how much time for further discovery, et cetera, et cetera.
Understood. I'm not arguing with
Yeah.
In that event, I want about 60 days, because I'm going to propound some discovery.
Okay. right, so discovery completed by July 31st? Is that what I'm hearing? And you need about a half hour?
Yeah, I would maybe set it, I would maybe say an hour. I think an hour would be.
August 13th at 1:30?
That's fine, Judge.
Attorney Wiley?
Our final hearing. That'll be a final.
Yeah, that's trial. Final hearing, whatever you want to call it. Attorney Wiley, yes?
August 13th, yes, sir.
Anything else? And that's at 1:30. All right, Attorney Shannon?
Your Honor, I represent Mr. Sharon Black, who's sponsored me today, the 5 grand first page.
Right, I see that. And then all other parties fail to appear.
This is another one, where we just requested a reimbursement, so I just need to submit whatever documentation to Attorney White and I should make it. That's the notice. So we can have that in August 11th as a status, and if I've done it by then, I put my hand on it, or give it a back,
Okay, so that, all right, so what are you asking for on this?
We were asking for a reimbursement of expenditures.
Essentially, that's for that same status date of August 11th.
Well, I know, but this is a different issue.
Okay.
The one before, my understanding, correct me if I'm wrong, was they were asking for a refund less 25% of what they paid for the tax sale certificate, correct?
On her previous filing.
Okay. This petition is for entitled Petition for Rate of Reimbursement from Redemption Amounts Consistent with Actual Costs of Purchaser. And they're asking to be reimbursed the cost of the title search, the cost of noticing,
And the cost of
The cost of publication and attorney's fees of $500.
We object to that, Judge. We don't make those payouts for that. The parcel was not redeemed by the first.
That's why I'm trying to figure out what the issue is here.
Well, apparently her issue, she wants to be paid for expenses when we didn't do the notices. The parcel was not redeemed by them.
Right.
And we object to that. We will not do that. So that needs to be set for trial. That's what she's going to ask for.
So Attorney Shannon,
If we could just set the status date and then, I just need to confirm that my office submitted.
because the petition you filed is basically for the expenses.
Right. And so I need to just confirm that, see what my secretary filed. So I can make sure.
Okay,
If not,
all right.
just reply.
Okay, all right, we'll set it for status August 11th.
Okay?
Because I wondered why I set it for 41E dismissal. It was set for 41E, and I think I did that because I was really unsure what the request was for relief. So I'll deny the 41E at this point, 41E, and then we'll set it for status
Yeah, and we'll withdraw the petition.
August 11th, 2015 at 11. And if you want to withdraw it between now and then or file the proper petition, if that's what you're really wanting is a refund less 25%, you should withdraw the petition you filed and file a petition for refund. Okay? All right. Attorney Smith.
Your Honor.
City Gary Redevelopment Commission versus Ivy. Jesse Ivy, Deborah Ivy.
Your Honor, you may recall we had a hearing on several properties a couple of weeks ago.
Yes.
I actually left, and I believe Ms. Shannon had, Shelley, I'm sorry, had shown up back.
What's your name, ma'am?
Esther Shelley.
Esther Shelley, on both properties, correct?
That's correct. You're on both Johnson properties right now.
So I saw the name, quick play here. Only saw 2439 Johnson, I think it was.
There are.
How do you spell your last name, ma'am?
Shelley.
Did you get a copy of the court order that came out as from last hearing?
Yes, I believe so.
Basically, is your address correct in the file?
Match to on that, my color.
Yeah, hold on. How are you related to this property?
Deborah Ivy and Jesse Ivy's my mother, and they signed my name in on the quick claim.
All right. Attorney Smith, is there any discovery that's still outstanding, or have you been able to?
Judge, actually, before, because I wasn't here at the time of the objection, I wasn't able to. But my understanding from Ms. Shelley is that she's not contesting the notice issue. She is simply here to let the court know, and I'll of course let her speak for herself, that they would like time to redeem the property and get the money together. So that's my understanding, is that she did not contest the notice, that she got notice. That's why she showed up in the last hearing, that she wanted to inquire to the court about the options.
Okay. Is that it, ma'am?
Yes.
Okay. Attorney Smith, is that something that you wish to discuss with?
City Gary Redevelopment Commission, yes.
Yeah, okay. So we're going to set this for trial, and see if you can work it out in the interim, or you just want me to set it for a status down the road?
I'd say let's set it for, if we could, a relatively quick status, because I think probably get an answer. And I explained to Ms. Shelley today that, one of the properties is over 13,000, the other one's over 8,000, so it's not an insubstantial sum. These are properties that are, in my opinion, pretty poor condition. And so they're going to talk with their family as well and decide if that's something they want to do. I will, but if you get that over for status 30, 45 days, I think that's appropriate before you guys can.
May I ask a question?
Yes.
If the property was sold, or was there commission? Redevelopment commission. Is there any possibility to get the property back?
Well, that's what he's just saying. He's saying that basically that I'll continue this out so you have time to discuss that with them. What he's saying is the taxes owed appear to be $8,000 on one and $13,000 on the other. Based upon the court's experience with this the program that's going on, is my understanding is that these are set for demolition.
It will be, yes. The city or their agent, in this case the redevelopment commission, has to have ownership of the properties for the money to flow from the state. But yes, the idea is to get the tax deeds in the redevelopment commission and then apply to the state for funds for demolition.
So essentially what he's saying is you're both asking the court to grant some additional time so you can try to work it out where you could redeem the properties. If not, that we would go to a hearing on it for me to determine what ultimately would happen based upon the noticing that was done and based upon the law. Okay? Do you understand that? Do you think you can figure all that out by August 11th? Or is that too long?
Absolutely, yeah. We can figure it out very quickly. I'm pretty sure the city's position would be that they'd like to be.
Okay.
But, so if that changes, I will first contact you.
What's the timetable on the program?
It's ongoing. I mean, the money's been earmarked. It's just a matter of, there's nothing that, at this point, they've been granted an extension because this process takes a while. So
August 11th is not, okay.
Will that be for the full hearing, Judge, or is that just for status?
I was going to set it for status, but if you want me to set it for a full hearing, I can do that too.
That'd be fine.
Okay, then we'll do that August 13th at 1:30.
So the August 11th date will not...
No, we won't, we won't do it on August 11th, we'll do it August 13th at 1:30 for bench trial. And if you work it out between now and then, fine. If not, then we'll resolve it that day.
All right, and I will be in contact. Thank you, Judge.
Okay. Attorney Bullock.
Good morning, Ron.
Good morning. First page, fourth item down. Victoria Jones, Ricardo Camp.
I'm here on behalf of Victoria Jones.
Okay.
The judge, we had initially filed a petition, voluntary petition to dismiss our petition for tax deed.
Okay.
We've reconsidered that option, and on Friday, we filed a motion to essentially withdraw that petition. But it's titled as a motion to dismiss, voluntary motion to dismiss. But we're actually trying to withdraw that petition for a different ground. So what we're here for today is asking the court to dismiss our original petition to motion to dismiss our petition. We're withdrawing our last motions.
All right, so you had originally filed a verified petition for issuance of tax deed.
Right.
Then you filed a motion to withdraw that along with a request for a refund of 25%.
Exactly.
That's 25%, which is why it got set for hearing.
Right.
Now you're withdrawing your motion to dismiss and proceeding with regard to the initial verified petition for issuance of tax deed, or What are we doing here?
Well, at the moment, what we want to do is withdraw the original motion that we
I
filed.
understand that. You want to leave, or you want to refund?
We want to leave.
Okay. All right. When did you do the noticing?
Actually, what happened was that
Because there was a verified petition for deed filed in August of 14. Apparently nothing happened off of that, because then I see in the file that there was, the redemption period was extended to January 24th, 2015, a couple months ago.
and so we did not serve the certified mail to Mr. Camp. We publicized it. We didn't serve it by certified mail. So that was the original reason why we set it for dismissal of the petition. What we're going to do is ask the court to extend the redemption period. Mr. Camp has not appeared. He's not in the property. All we need time to do is send the certified mail. We didn't want to send the certified mail after the period had expired. But if the court grants us an extension of the redemption period, it's simply a matter of sending in certified mail. We're coming back and asking the court for leave. There are no objections in this case at all.
Okay, what motion, I mean, presently there's no motion really before the court to even act on.
What I hear him saying here is,
Well,
asking for an extension.
well, right, that's what, true, orally.
Right.
You know, I require those to be in writing. What did you say you filed on Friday?
A motion to withdraw, voluntary motion to withdraw the.
Because I don't have the latest filings.
Okay, I have a copy of it.
Okay. What you're going to need to do is file a petition to extend the redemption
I'll
period.
get that done this week.
Okay. And we'll set that for hearing August 13th, 2015,
Is that in the morning, Judge?
1:30. Yeah, 1:30. You understand what I'm saying? Yeah.
I do, absolutely.
And I'll grant your motion to withdraw your motion to dismiss your petition.
Okay.
But now we got to get back up to square one with, you know, if your request is the petition to extend the redemption period.
I'll get that filed.
Yeah, get that filed, and that'll be set for hearing, and unless, if you can reach an agreement, is there an agreement to extend it?
There's not, Judge, I need to look at the history of it.
All right. All right, so going to set it for August, status August 13, 2015 at 1:30.
Okay.
All right?
Thank you.
And, yeah, and get that on file. Yeah, all right, yep. Attorney Kavachkov, is he still here? Attorney Bratz.
Yes, sir.
Premier Holmes versus Tracy Robinson. Okay, Tracy, let's treat you Tracy Robinson.
Yes, sir.
All right. And what is this the status of an objection to a tax deed?
Judge, the tax deed was issued last fall.
Yeah, I remember Ms. Robinson.
Yeah.
I actually was wanting to ask for time to obtain an attorney. I was in the hospital. I had a stroke last year, major surgery, December of the previous year, and was in the hospital on all of these dates as the gentleman came to the home and said, you've got to get out. And so I've brought documentation of
When were you in the hospital?
starting in December through January, and March through April. And then
Judge, would you like me to bring up the state on what's happening on this?
Okay, there was a petition for deed filed in July. It was set for hearing in September. Apparently, Ms. Robinson failed to appear. The petition was granted. My question, though, is, I'm absolutely crystal clear on the procedural history of this sale. Was this the subject of a previous sale that I ruled on? Because I remember Ms. Robinson
was the attorney. I sat through the entire hearing, and Mr. Wiley was the attorney for the auditor. Yes.
So there was a previous sale, there was an objection, and I apparently ruled in her favor?
I think Mr. Golding can fill you in on that.
well, actually, if I may, at that hearing, it was determined that continues to be an error with the billing, with the tax. And if I may, if I've got two attorneys here that are hearing, if I may, I'm back working normal hours. I would like time to get my own attorney because, the assessor's office.
I'm just asking some questions so I can get things clear in my mind, okay? So,
Your Honor, if I may, I will represent to the court, and if sworn, I would testify that my client was Affordable Indiana Homes. To the best of my recollection, they bought this property after the tax lien at a sale. I believe it was in 2011. She came forward and made a bunch of objections, which seemed to revolve around the taxes were too high on the property, and she couldn't understand why they were so high.
hold on, don't interrupt.
Ultimately, my client, a member of Affordable Indiana Homes, William Hackle, directed me to simply withdraw the petition because he just didn't want to pursue the matter anymore. So there was no finding of anything, Your Honor. The petition was simply withdrawn. And my client, if this becomes an equitable matter, I would testify that my client had made settlement offers to sell the property to Ms. Robinson's brother, which were ultimately rejected. And so ultimately we just withdrew it, but there was no finding of anything to my recollection.
Okay, so to answer my question regarding the previous case, it was simply withdrawn, and that was at the end of that, and then it went up on a subsequent tax sale.
Taxes weren't paid.
That's accurate.
Okay, all right. Go ahead.
So, I mean, it wasn't a finding, but even the assessor said that it was excessive. That bill is unreal. It's not me saying it. My mortgage payment went from $700.
All right, for the purposes of today, then I'm going to deem her filing a motion to set aside the judgment. Okay? You understand, ma'am? You filed something disputing the sale of the property, okay? So I'm deeming that to be a motion to set aside the judgment that was entered against you in September or October of 2014, okay? So I assume there's going to need to be some discovery regarding
Yes, Your Honor.
that. How much time?
Short date, Judge.
How much time You said you were going to get an attorney? All right, I'm going to set it for status August 11th at 11. At that time, ma'am, you'll need to, and discovery cutoff of that same date, August 11th, 2015.
Judge, could we get on the record for the correct mailing address for the discovery?
Well, she entered an appearance as Tracy Robinson at 576 McKinley, Gary, Indiana, 46404. So that's it.
I don't know that the house is habitable anymore. I just want to make sure.
There's 7 people living
Is that where you want your mail, ma'am? Okay.
And Judge, I would ask that she understand that she has to provide me with all the exhibits that she wants to introduce if she doesn't provide them with the...
Let's set a date for that exchange of exhibits of June 30th, 2015. Ma'am, what that means is anything that any documents that you ultimately want to show to me when we get to a hearing on the merits. Today's a status. This is a scheduling hearing. We're scheduling things, okay? One thing that's scheduled is by the end of this month, you need to give to him every document that you intend to show me when we get to a final hearing on this case, okay? And he needs to give you every document that he intends to show me at some point, when we get to the end of this case, okay? And then between then, or even now, and August 11th, if there's anything else you want from him, you need to ask for it, and he needs to do the same. If you want to take any depositions or conduct any other discovery as set forth by the Indiana trial rules. Then on August 11th, 2015, at 11, you'll come back and you'll both report to me that you've done all the things that I've said for you to do, and you've either reached a resolution or you need a trial date. At that point in time, I'll give you a trial date, probably within 2 to 3 weeks of that date. Okay?
Your Honor, for the record, too, I'm going to tender to Mr. Robbs his pre-sale notices, and he will supply a copy of that to Ms. Robbins as well.
He'll send you a copy of that. That's the pre-sale notice that was sent out by the auditor, putting it on the tax sale in its first instance. Anything else? Okay. Attorney Bronze, do you have any other 930s?
Anything else, Judge? I had something with Attorney Cyrus
That was this afternoon. I think that's settled, right?
that did settle. So,
You have anything else this morning?
CBD,
That's at 11:30, so...
that's already been resolved, Judge.
Okay, it has?
Through his Trial Rule 60B motion withdrawn, and therefore denying my client got the deed, so
Okay.
I don't think there's anything to do on that. I think that's separate.
So we'll show that one as moot and vacated. That's CBD Holdings, Jamal Rogers, the one at Jamal Rogers here.
I think that was Ed Hall's case.
Okay. On page 1 of the call, Barden Procurement Group, that's a duplicate, so I'm just going to strike that on today's call as a duplicate. That's the same as the top item on page 2. Attorney Kavachkov come back? No. All right. Moving along to the 10:30 call, Attorney Tweedle. Francesca Hope. Come on up. You're not Francesca Hope? No. Okay, then sit down.
9:30.
Oh, you're 9:30?
Yeah, 9:30.
Okay, come on up then. Hold on.
This is your 9:30. What they're talking about.
Oh, Angela Smith? Okay.
Good morning.
Brennan Nash. Well, Attorney Jones walked in just in the nick of time. You represent Brennan Nash, correct?
Yes, I do.
All right. And, let me find this. You are?
Angela Smith.
Okay, Angela Smith appears self-represented. And sir, what's your name?
I'm Morris Carr, I'm a cousin, but she has me.
Okay, all right. Okay. They filed a motion to vacate the tax sale, and I set it for status today.
Okay.
And I assume there's a need for, is there going to be a need for discovery?
Yes, when I believe that property I filed
Let me look. She's saying she didn't get notice. Let me see. Is there a deed on this? Anybody know? Okay. Let me look. Okay, the present state of the record is this. The redemption period has been extended to August 17th, 2015. Okay? So, between now and that date, you can just go to the auditor's office and redeem the property and the case is over. Okay? Or we can set your petition to set aside the previous orders for hearing, but you're still going to owe the taxes. Do you know, Gina, do you know what taxes are? Like a ballpark?
In excess of $5,000.
Well, I'm requesting to, pay mine.
I don't know if that's something they would entertain or not.
It's not something that's available.
Yeah.
It's a little more.
One option, since the redemption period is extended to August 17th, is to come up with whatever that money is and pay it by that date.
Okay. Okay. Also, can I put out the fact that I wasn't notified?
Well, that's if we go to hearing on that, okay, and you were to prevail, then we would basically go back to square one, but you'd still owe the taxes, and you'll probably end up on another tax sale. Which, I mean, if that's the way, I mean, it's up to you. You just tell me which, I mean, you've got a pending motion. I'll set it for status sometime after that August date, and we can see what happens. They might not even go forward with noticing or their petition or anything.
I think in the event that she does, and it rules in her favor, and the responsibility of reimbursing the client would then fall to the county, I think. If in fact she was not notified.
What's your address, ma'am?
And I have a question. Is this objection based on no notice from the auditor's office, or is it no notice from the tax sale purchaser?
I received no notices from him.
Well, I would assume, well, what she just said, and my assumption would be that she received no notice from the auditor's office, the pre-sale notice, because we haven't even gotten to the point of the tax sale certificate purchaser giving notice, because you haven't.
And actually, I don't believe she challenged the action of the burning.
Well, he hasn't done anything yet, that's why.
Right. She was challenging the fact that she was
Ms. Smith, whose address is 2221 Ohio Street?
I haven't lived there since 2010.
And so then you haven't said a change of address with the auditor's office either.
Yes, I have. I have it here.
That's the new. She said, oh, but it didn't go through.
In March of this year. This is from a sale of 2013. So you just filed your change of address notice now.
This was the second notice I filed.
Okay. I just want to find out what that address was, because that's on the auditor's record, that's the address you wanted your tax bill to go to.
No, actually,
I live on the premises for the property that went to tax sale, so I should also have been notified.
All right, then I'm going to set it for status. So, ma'am, if you want to redeem, you would need to do so by August 17th, okay? That is your safest way to handle this matter, is to find out from the auditor's office what that amount is. Save up that money between now and August 17th and go in by the 17th. If you go in the 18th, they will not take it.
And I have to pay whatever the same I have to pay.
August 17th, you said, was the status date?
No, that's the redemption date, so I was going to... do you think you'll know by August 13th whether or not you're going to redeem it?
Yes, sir.
Okay. Let's set it for status then, August 13th at 1:30. And I would aim towards that date to bring the money,
August 13th.
so you can redeem it that day. But I would say today, I don't know, Ms. Scheidt, when would you be able to give them the exact number?
They go downstairs.
Okay. Would you tell them where to go?
I know where to go.
Auditor's office.
Okay. All right. And Attorney Jones, okay. August 13th, 2015 at 1:30.
That's fine.
All right, anything else on that? Clinton Cummings, Sherry Johnson. Are you Clinton Cummings?
Yes.
Are you a tax sale purchaser?
Yes, sir.
All right, let me find that file. All right. This is concerning key number 45-08-210-003.000-004. Okay. You had a previous hearing date of April 17th, which you didn't appear for.
I was in an auto
Okay,
accident.
hold on. And then you filed something that day. Basically, I'm going to deem it as a request for a continuance. However, that didn't come to my attention until after the hearing on April 17th.
Yes.
At the hearing on April 17th, we denied your petition. Attorney Wiley was ordered to file the order consistent with the court's ruling, which he did, and was entered May 11th. I set your filing on the 17th for a motion to set aside because I had already ruled against you. So we're set for a hearing to set aside. You're stating to me that you were in an auto accident?
Yes, sir. I was in a minor claim together, and I got here, but I got here late.
Okay.
Around this time.
Attorney Wiley, any objection to setting aside that order?
No objection.
Okay. All right, then I'm going to set aside the order denying issuance of tax deed and denying refund. We'll start over. Have you looked at his notices? Is there,
I haven't seen anything, Judge.
do you have your notices, sir?
We're just set it for a status, Judge. We'll have to take it later.
Yeah.
Just checking for his notice.
Maybe she can look at them now while we're proceeding.
Sure.
And if they're okay, then... Mr. Cummings, just have a seat over here. That should conclude our 9:30 call. So let's start with the 10:30. Attorney Tweel.
I've got some ministerial get the ministerial individuals out of here, and then perhaps, because you just set petitions for people, right?
Correct.
If that's, he'd say he would have to stick around for a little bit if he wants to.
Well, his are set for 11:30, and it's not 11:30 yet.
So I thought it was at 5.
Okay, so, I mean, I would get him out of here, but I don't know if other people are going to show up, and when it's something set for 11:30, I usually wait till at least 11:35 or 11:40, because based upon my experience, as soon as I rule right at 11:30, somebody walks in at 11:32. No. So we'll do at least a few for 10 minutes, and then about 11:40, we'll take Attorney Viz out of order and let him go, but I don't want to do that just yet. So, Francesca Hope? Yes. Oh, that's the bench trial.
No, that's not. Well, these are all separate trials. We're doing different things. There's only one that we're actually going to have a bench.
All right, so, Francesca Hope, that's you? Felicia?
1244 Allen Street.
Okay, so this, Your Honor, we're requesting to continue this trial to the date, the 8/11/15. Date, if that date works, because
I'm sorry, the what date?
the date that I have that you're continuing things till, and I have another one that you set for August 11, 2015, 11 o'clock. I would ask that we continue this bench trial to that date, for that call, if that works for the court.
You do have one that date? I would be continuing it for...
I have one item that was continued.
I'd be continuing it for a status,
Yeah.
not for a bench trial.
That's correct.
Because we've got a bunch of stuff already.
Is that,
Or do you want to do it on August 13th at 1:30?
well, what we're trying to do is reach an agreement. I don't think that we would have a bench trial in any circumstance.
All right, then August 11th at 11 is fine. Ma'am, do you understand that? We're going to continue this for status to August 11, 2015 at 11 a.m. Okay? All right.
Judge, for the record, I'm going to hand Mr. Tweedle our pre-sale notices and when Ms. Hope at her address at 1244 Allen Street. You can supply that for in the event they go forward. Yes.
Just for the record, Ms. Hope is acknowledging that she's previously received this pre-sale notice.
I agree.
Okay. You're welcome. U.S. Bank custodian, Floyd Spells. Mr. Spells, do you want to tell me which one you want to take next, or which one's the bench trial?
The bench trial is 2428 Madison Street.
Give me a name.
It is,
Okay. Mr. Spells.
Your Honor, we were here for a status April.
Correct.
And so represented the court that the property is not worth what it's being taxed for, but he wasn't inclined to redeem at the time, and you had suggested that we set it on for another status hearing. I discussed the matter with Mr. Spells, and if the county is inclined to agree, we would agree to cancel the sale, which would give Mr. Spells an opportunity to contest his taxes if he wants and to pursue. So instead of extending redemption, we would just agree to cancel the sale. I discussed the matter with Mr. Spells. He didn't approach it, but I
The county would object, Your Honor, unless Mr. Tweedle's agreed that he's not going to proceed as any interest on the purchase.
Okay, so what I'm hearing is the auditor's office would be willing to refund the price of the tax sale certificate, and that's it.
Correct. No, that's not a voluntary dismissal, not a decision. They chose not to go forward. The statute allows for
But you wouldn't object to us receiving a refund from the purchase price? The full purchase price. I will agree to that, Your Honor.
Attorney Wiley, is there agreement?
There's agreement, Judge.
Mr. Spells, you agree?
Yes.
You understand the terms of the agreement?
Yes, sir.
Okay, they're going to cancel the sale, they're going to go back to square one. there's going to be a reimbursement of the tax sale certificate money to them, which really has nothing to do with you anyway. All right, parties report agreement. Attorney Tweedle will reduce that to writing and file it within 14 days.
14 days.
Yes? 21 days?
21 days is better.
All right. All right, U.S. Bank Custodian versus Theodis Kirkwood. Is Mr. Kirkwood here, or somebody on behalf of Mr. Kirkwood?
Mr. Kirkwood is here, Your Honor.
Are you Theodis Kirkwood?
Yes, sir.
Okay.
Your Honor, we've reached an agreement with Mr. Kirkwood and the county to approve this agreement where we would extend or provide an extended opportunity for the respondent to redeem the property. And prior to doing that, he would reimburse us for our 4.6 costs and some additional expense, which would be paid in 30 days, which is totals $482. At which time then he would have the opportunity to redeem the property within 60 days of today's date. If he ended up not redeeming the property, we would ultimately receive a tax deed, but he would receive a refund of whatever amount he paid us for our 4.6 additional expenses.
Mr. Kirkwood, did you hear the recitation of Attorney Tweedle with regard to your agreement?
Yes, sir.
Is that in fact your agreement?
Yes,
Are you asking the court to approve and adopt that agreement as the order of the court?
yes.
Attorney Wiley, any objection to the agreement reached between the other two parties?
No, Your Honor, no objection.
All right. Court will show that the parties reported an agreement, approve it, and Attorney Tweedle, you'll file that within 21 days, or do you have it now?
I have it now for the time to sign.
That's fine.
Ready to approach?
Yeah, just on the table.
Oh, you still leave it?
Yeah. Yeah, I can't sign it now. All right, very good. Mr. Kirkwood, you'll get something in the mail. And obviously, you know what you need to do, so you need to follow those terms. All right? Understood? Okay. U.S. Custodian versus Chuck Smiley. Is Mr. Smiley here today?
Mr. Smiley and my client have reached an agreement with regard to the property, which would involve us receiving a tax deed for the property, and then the agreement would take place once my client is the record owner of the property. Mr. Smiley has discussed that arrangement directly with the client, and it's my understanding that based on that, Mr. Smiley has no objection to our petition for deed.
Mr. Smiley, is that correct?
Yes, sir.
Okay. You understand the terms of the agreement that you've reached with the other side?
Yes, sir.
You understand that there are certain things that are going to go on outside this particular case and cause number?
Yes, sir.
And are you asking the court to approve what you've asked me to do in this particular case and cause number?
Yes, sir.
Attorney Wiley, any objection?
No objection, Your Honor.
Court will approve and adopt the agreement of the parties as reached and reported in court. Attorney Tweedle, you will prepare that and file it within 21 days?
I certainly will, Your Honor.
Anything else on this case?
Nothing on this case.
Very good. Okay.
That's everything.
Everything except for Angela Mitchell. Is Angela Mitchell here? Okay. All right. We're going to call you later once we get done with all the other statuses. That takes us to the 11 o'clock call. That's going to be continued. There was a continuance filed by Attorney Hatcher. and there was no objection to that by Attorney Stark, so we're going to get a new date on that. All right, Attorney Viss.
Yes, good morning, Your Honor.
Good morning.
Thank you to Attorney Cole for allowing me to interject here. I appreciate that.
I believe these are all petitions for deed on page 3 of the call, Judge.
They are.
Judge,
Are these the ones that you assigned and withdrew?
There is one that was assigned and I also withdrew, but just received notice of that yesterday. But I do have with me today notice of final notice to the persons that did own the property. As I didn't receive the notice that I was allowed to withdraw until yesterday, I still had that prepared in anticipation that the court would not allow me to withdraw. So I can't file that today, as well as I do have the proofs of notice for all the others that I'm still not here on.
Okay, any objection to any of these?
No objection to deed on any of the parcels.
All right, we'll show the petitions granted.
Judge, would you like me to submit to the clerk's office or an open court here?
Right here on the table, yeah. You have the form order for each of them?
Yes, that was already submitted.
That's already been submitted?
Yes.
Okay, have you had an opportunity to look at those?
I believe I did.
Okay, all right, very good. All right, Attorney Drake, what are those that
The notices of today's hearing is what I was going to submit. Or should I just run those through the clerk's office?
you don't even need to file them anywhere?
Okay.
You're talking about the 4.5 and the 4.6? You don't need to file them, unless you want to put them in as exhibits, then we don't normally do.
There's not any, no one has appeared in the opposite
Right.
side, so we'll just hold them for
Yeah,
last hearing.
yeah.
Thank you.
Yeah. Krishna Dobbs versus Michael Ballard. Michael Ballard. Attorney Drake, who do you represent?
Christian Dobbs.
Okay, and this is for deed?
And this is a case in which we were to reserve 4.6.
So this is for deed?
Petition. And we have served all the parties. We served all the parties. 4.6 contained a scrivener's error containing the wrong hearing date. And so we were to reserve it with today's date as hearing date, which we did. And we have a certified bill determines for all of the persons who are entitled to notice.
That's correct, Judge. We have no objection to the issuance of the tax.
All right, we'll show the petition granted. Attorney Drake, have you filed your proposed order?
We have the proposed order here, Judge.
Okay. It's right up on the table.
If I may, there's a little more further. It's not on the call. You know, we sent it to the court, and this judge was a matter of property in the area 4757 Broadway.
Do you have anything from me setting it for hearing today?
No, I don't. Judge.
Okay, then
and I'm not sure if it would require a hearing. That's why I wanted to ask. I haven't had a chance to ask it well. Stipulate to it that the order, the only error is the proposed order had the wrong street name. Instead of Broadway, it had another street name in the order.
Okay, so let me, so I'm clear. You have an order granting issuance of deed.
Yes.
And then there was a proposed order that was prepared that was inaccurate.
Yes.
Okay.
The street name was
You need to do a motion to correct the scrivener's error?
Yes.
In writing, and you need to file it, and then when I get it, I go ahead and grant those as long as the initial order was entered by default.
Yes, sir.
Okay, So you'll need to file something in writing?
And he just did on May 29th, Judge.
Oh, he did?
They just filed it, and it's just not on default today, obviously, so.
Once it comes up and, excuse me, once it comes up and I look at it, if it's simply a motion to correct the scrivener's error from a previously entered order, then we'll just process it without the necessity of a hearing. Okay, so just check your mail in a week or two. All right, yep, you're welcome. All right, Attorney Jones? All right, we're on the last item on page 3 on the call, and every item on page 4 except that last item. These are all petitions for deed. Is there anybody here, other than Angela Mitchell, objecting to deed? Anybody objecting to a deed? What's your name, sir?
My name is Jawan. Remember the property is for Jamal Rogers.
Middle of page 3, David Rogers.
Oh, Attorney Bratz said that was withdrawn. No? All right, we'll call it here in a moment. Just have a seat. How about you folks in the front row there?
Yes.
Oh, yeah, what do you have? Oh, you're Mr. Cummings.
No.
No, okay.
Okay, it's 820 Rhode Island Street and 771 in Chucky Street.
What's your name?
Sandy Moore, New York.
Oh, okay. See, okay. You got a petition.
Correct.
Yeah, you're next. So have you had your notices looked at by Ms. Scheidt?
No, sir.
Okay. Marjorie Pandy, is anybody here on the other side of that? With regard to Mr. Cummings, did he,
His notices are improper, Your Honor. He has no title work today, and the notices are improper.
okay, well then we'll call that in just a moment. What about Attorney Jones?
Attorney Jones, we have no objection to deed on the petition, Your Honor.
All right, we'll show those petitions granted. Have you filed those orders? All right, petition granted, Attorney Jones to file within 21 days.
And I see that this matter had been filed earlier. I apologize for not being here, but I did notice that we were going to be set earlier than that. Was at home.
Let me address that here in a moment.
Thank you.
I forget why I sent for status, but basically, that's the one you guys already had a bench trial on. I had it under advisement. Attorney Hall indicated that there's been some changes in the case law or something, and he requested an opportunity to brief that particular legal issue, which I said that both of you could have 30 days to brief whatever an issue is. Whatever the legal issue was, I have to go back and listen to the tape. I remember it somewhat. He gave a nutshell version of what it was. File any other further briefing by June 30th, 2015. And he waived the requirement to rule within 30 days, the 53.1 and 53.2. You'll do so also? Okay. So that's that. Anything else? All right. All right. Okay. So that leaves us with Mr. Moore, Mr. Cummings, and one trial. Clinton Cummings, come on back up, sir. Oh, here he is. All right. So,
Your Honor, the notices are not an order for issuance of deed, as such the auditor would reject the issuance of deed.
Mr. Cummings?
Your Honor, I have every notice that I've sent out but the original one. I moved and I didn't receive when they returned it. I never got it back.
I'm sure that it was sent back, but I didn't receive it. The others I sent from my current address, and I got all of those.
Well, I'm sorry, so you're saying you don't have proof that you sold the 4.5?
Well, I have just the receipt from where I sent them, and I don't have the actual orders, the actual.
The green card?
Yes.
What does he have, the green card?
He has the receipt that he mailed it, that he mailed something. I mean, we don't have a copy of the 4.5 notice, we did a copy, read to make sure it had correct information.
Do you have a copy of that?
We need a copy of the title work to show that he's sending it to the proper people, which he doesn't have that either. I mean, that's step number one, to show his title work that he's sending the notices to the right people. So at this point, Judge, the auditor would, our position is in this types of situations, either he can get a refund minus 25% for failing to properly notice, or if he wants to extend the redemption period from today's date, 120 days again, redo the notices, trying to keep. Those are the options we would make in order.
Mr. Cummings?
I would like to extend the date so I can read some purposes.
Okay. We'll show that the redemption period extended 120 days to what?
October 2nd.
Say extend redemption to October 2, 2015. Okay?
You have to notify them that due date. That's the date, that's the notices, October 2nd. So we're just writing it down and understand it. Okay.
So he has to do both the 4.
Do the 4.5 and the 4.6 again. So the 4.5 has to go out within 90 days from today. Advising them that they have until October 2nd to review the partial. The notices you send out, you can keep copies of them, so you can see what they say.
Yes, sir. Thank you very much.
And then the 4.6 needs to go out.
When we have a new hearing date, we don't have that.
Right.
When you get the hearing date for the tax deed day, because he won't be able to make that last day. We can give it the cutoff date of October 30th.
Right.
He won't be able to get on that. Wait.
All right.
So just do the 4.5 now, and then file your petition for tax deed after that.
Thank you very much.
Yep.
October 30th.
All right. Are we ready for Samuel Moore and Marjorie Pandy? This is the last item on page 4, 4508, 03454, 013.000.004.
This site has reviewed the notices, Your Honor. Same thing, Your Honor. They have two options. They can either accept the refund minus 25% of what they paid, or extend the redemption period to that October 2nd. This one, the petitioner had already received an extension once before. Can you pull a file on this one, Judge, to see if there was an extension? I asked this one once before. For Mr. Samuel Moore, which was the Marjorie Pandy file. It's the last item on page 4.
This indicates that the redemption period was extended to May 12th, 2014. And then subsequently, now there's a petition for, the petition for deed was filed January 23rd, 2015.
And the notices that they provided us today, Judge, after that extension was granted or improper or incorrect, as such, the auditor, as you know, did not grant or agree to multiple extensions. Our position is that attempts have been made as far as notice that they're entitled to a refund minus the
Go ahead.
Yeah, the attempt that they made to process the paperwork last time we were able to 17, the exception of the title of the paperwork was there, and the title had been conducted, title search had been conducted, title paperwork was in there from 2014, and so in fact, this actually, we're demonstrating the title search had actually been accomplished since then, and you're scheduled for June 2nd today.
The issue is not simply the lack of title of judge. The issue is all the notices are improper on dates of redemption. Date is improper, incorrect listing. There's multiple problems. It's not just the lack of title work. It's improper redemption provided, improper timing as far as the receipt of the notices.
What are the notices for this?
The sale date is wrong. It's listed in the notice. Everything is incorrect.
Okay, Mr. Moore, you have a response to that?
I'd have to go back and look. They're saying I have to go back and look through the validity of it. That's all I can say.
Assuming they're correct, I've ruled on this issue many times. If you put the wrong redemption date in and put all the wrong dates in, then I would deny your petition. Obviously, I'll give you a chance to go back and try and ascertain that. What they're saying, though, is, and what we've done in the past, is if you have improperly noticed it, they'll give you a refund of what you paid, less 25%.
Yeah, I understand that.
Is that something that you're in agreement with, or do you want me to reset this for a bench trial on the issue down the road?
Please, I would like to do a request.
All right, August 13th, 2015 at 1:30. Okay? 1:30.
August 13th, 2015?
Yep, at 1:30. Bench trial. All right, anything else? All right, Mr. Reynolds, come forward. Hi, Attorney Bratz indicated that this case was settled. Apparently, he must have confused it with one of his many others. Is this the property line dispute case? Is this the one where your garage is?
Correct. I spoke with someone, with his client, and we did come to an agreement. We haven't written up anything or anything like that.
Oh, you did come to an agreement?
Yes. He agreed to the settlement certificate.
Okay. We'll show agreement reached. Parties. Has anything been filed on that you know of?
No.
All right. Agreement reached. Parties to file. Attorney Bratz, I'm going to order to file within 21 days. I think he did say it was settled or worked out or whatever. Yeah. Attorney Bratz to file within 21 days. Okay? Which leaves us with, on page 3, U.S. Bank, custodian for TCLF 2012A LLC, which is represented by Attorney Tweeter, Angela Mitchell, concerning 4508-020.000-004. And you're Angela Mitchell? Okay, Angela Mitchell, pure self-represented. And sir, what's your name?
Renee White.
Renee White?
Yes, sir.
Appear self-represented. All right, let me find that file. We're set for bench trial today?
That's correct, Your Honor.
Are we ready to proceed?
Before we proceed, I wanted to ask a question, because we are represented, and I don't know if this is a very important matter, and if we would like for a chance to get an attorney, if possible, to extend the trial, so we can get the attorney.
Okay, so you're asking the court for a continuance?
Yes.
Okay, hold on, just let me find the file. Okay, yeah. All right. All right, Attorney Tweedle, they've asked for a continuance. What's your response to that?
No, I'm going to object. We've been in court many times. We were set for originally, I think this was the December 2014 hearing. Then we had a hearing in January, which was the status. Then we had a trial set, I believe, for March.
Okay, now the original petition date was December 5th. There was an objection filed, so the initial pretrial conference was set for January 28th. At that time, the parties, either the parties agreed to or the court reset it for status.
Correct.
On April 14th, 2015. And then at that point, the court set it for trial.
For bench trial for today.
Yeah,
Correct.
right.
And we were ordered to exchange documents, which I exchanged my documents again at the county. Attorney Wiley also exchanged his documents prior to the last status hearing. So this has been in the works.
Okay, and then you're asking, you want time to do what?
Attorney. This is,
Go ahead.
This is an important matter, and just some of this paperwork. I feel we have a case, but I'm not sure if I can represent it.
What's the issue from your point of view?
Well, I mean, the issue boils down to, I don't think there's any dispute about notices. They are contending that, at least the way it's been explained to me, that and I would have Gina testify to the fact that this property was sold at the September 28, 2011 treasury, or it was up for sale September 28, 2011 treasury sale. Did not sell at that sale. It did subsequently sell at the June 28, 2012 commissioner's sale. The redemption date expired on October 26, 2012. However, there was an extension of the redemption period through January 11, 2013. For some reason, there was an additional extension from January of 2013 to February 8 of 2013. I'm not quite maybe able to party showed up.
I have paperwork here that was from February 11th, 2013.
Yeah, February.
To be redeemed, and we redeemed it February 7th.
Excuse me, so let me you'll have a chance if I'm not properly characterizing it. They redeemed it on February 7, 2013, and they came in and paid the taxes, which paid it back through the September 28, 2011 tax sale. Didn't pay all their taxes, but they paid what was necessary to redeem it. There was still, at the time that they came in to redeem, the amount was approximately $8,057. They paid $48.51, which got them past the tax sale aspect, but there was still an additional approximately $3,200 that was owed. They had not paid any other subsequent taxes. So this property then went up for tax sale at the September 2013 tax sale when my client bought it. They received a pre-sale notice. I don't believe there's any dispute on my notices. They got the 4.5 and 4.6 notices, but their take on it was they didn't have to redeem it because the county's not supposed to sell the property again for 18 months, which I'm assuming is an interpretation on the county's 3 tax sale installments unpaid before the county sells the property for sale again. But that's their understanding, is they've got this 18-month date. So they didn't redeem the property, they didn't pay any taxes, and now they're saying that the county should have sold the property. And I'm prepared to show that there were 3 unpaid installments, which is why the property sold, that we did all the noticing that we were supposed to do, and that we're entitled to a tax. And I'm prepared to call Gina to testify to every aspect of it.
Okay. Do you have an attorney in mind, or who do you, I mean, when do you think you can get an attorney?
Maybe 30 days, if you will allow. May I address some of the issues there, why I believe we have a case, or is that necessary?
Today's a status. I was just trying to get a picture of what nothing that was said today by either one of you is evidence that I would consider in the trial.
You just said on the record that today's a status. Today's a bench trial.
I'm sorry, today.
I just wanted to make sure.
Today we're set for a bench trial. They moved to continue it. Obviously, when someone's losing their property, it's one of the biggest issues you could have in the legal arena. Life, property, imprisonment, it's right up there, losing your property. So I don't take it lightly at all. So this is the first bench trial setting. I normally would grant a continuance. This is something that I think is an issue that I've not particularly had straight up yet. So I think that these folks would probably benefit from having an attorney to fully present the issues that they have. So I'm going to grant the continuance. And I want to make sure that are you going to get someone, or next time you're going to be in here? All right, I'm going to set it for status on August 11th at 11, and at that point in time, hopefully you've got your attorney, he or she's up to speed, has talked with Attorney Tweedle, and then we'll give you a bench trial date, within 2 to 3 weeks of that date. So Just so I'm clear, you thought you redeemed it and didn't need to do anything further?
Correct, because when we paid actually it was 57,506. Then we paid with the attorney fees 4851. Went to redeem it. We were told that in order to redeem it, all taxes owed and current had to be paid. So once we paid the 4851, we thought that we were all current. 9/14/13, I lost my job. Then September 24th, 13, we get a notice that it's being sold, and we're like, how is that possible when all taxes should have been paid to redeem it? I have a receipt where it doesn't say any balance is due. It was never, okay, you paid 4851, but this is due. Nothing was ever told to us like that. We redeemed it. We were free and clear, and then less than 7 months, it's up for sale again.
Okay, so we'll continue it's granted, set for status. Eight, 11, 15, and 11. Yes?
Yes, sir.
All right. See you then. Yep. All right, I think that concludes today's call. Is that correct? Is there any items on the call that, Attorney Wiley, that you see that we didn't address?
No, I think that's very I'm sorry, I should have talked to you ahead of time about that. We did talk before about that one. Everything's been covered.
Okay, very good. All right, anything else?
And then we're going back to one that said but I didn't think we were talking about that. I told Randy, like,
All rise.
Hey, Ed Hall's going to be coming back. He left his file in, so I'm going to leave it on your desk if he walks in. I already had Mike Shirley call his office to tell him.
Yeah, we're not going to be doing that. We're not going to put it.
Do you need this? Yeah. Oh. You want these orders, Mike?
We need them, and I'll bring them over.
Oh, shit, someone else left something.